There were a lot of cases in 2013. I can't go through them all, we just don't have enough time. So when I put this together, I tried to pull the ones that I think would be most relevant to your day-to-day practice. There's a lot of information, there are a lot of cases that I do think are important. You can weigh for yourself on whether or not you think they're as important as I do. And so time for questions is going to be very limited too, so that I can try and get as many people the information as possible. Okay, so the first area is paternity cases. It was a really bad year if you wanted to be a dad. The law was not on your side this year. We had NRA ET, which was a case out of Department 404. The petition came in, alleged the child was at risk because of conduct of the mother. Mother said, I'm not telling you who dad is. The department still found him. Not a real great dude. They alleged drug use, criminal history, including a conviction for willful cruelty to a child, took a bat to mother's car. Not really your favorite parent. The court did order a DNA test for him to prove that he was the father, and of course you can imagine the department turned around and filed a 342 petition on him. The court ended up procedurally hearing disposition as to the 300 petition against mom and the 342 against dad at the same time. Found him, the DNA came back, he was a bio dad. The court dismisses 342, returns the kid to bio dad. Mom takes it up. Court of Appeal reversed. And they reversed because only a presumed father is entitled to custody, not a biological father. And so father alternatively argued, okay, well then give me placement as a relative. And the Court of Appeal said, oh, you can't have placement as a relative because you're a dad. So I will leave it to you guys, when you have a bio dad, to try and follow the dots of the Court of Appeal on this opinion. But basically, bio dad, no right to custody. Only a presumed father has the right to custody, and they don't qualify as a relative because they're a dad. That's NRA ET. The next one was NRA TG, and I'm sorry because I know that the slide printed very tiny print on your handout. This is another one who is in the long-term Gladys L. cases about the requirement that we find unfitness on a presumed father before you can terminate parental rights. NRA TG was the same thing. It really was kind of a ping-pong match. Father wanted custody, father disappeared, the foster parents wanted to adopt, then they wanted legal guardianship because they weren't supportive. It kind of went all over the place, but eventually what happened was the court did TPR. The interesting thing about this case is father's trial counsel argued there's a C1B1 exception to the termination of parental rights. On appeal, appellate counsel said, oh, we have this unfitness problem. So if I were trial counsel, I would probably be shaking in my boots about whether or not I just committed IAC. So watch for those unfitness findings when you have presumed dads. Make sure that there's been a finding before the court TPR. The court basically said father's trial counsel waived that issue of unfitness, but it's a constitutional issue, so we'll consider it anyway. Banker does. And so the court basically, father had, in this particular case, he came a little bit late. He filed a 388 petition requesting reunification services, and the Court of Appeals decision kind of hinged on that little factor. Father was not requesting return. So the Court of Appeals said you cannot imply unfitness from the trial court's denial of his 388. You had to make a specific unfitness finding, and it's not satisfied by the denial of his 388. The other interesting thing is the department. It was an agency. This was not an LA case. The agency tried to argue that unfitness was not required, only best interest, and the Court of Appeal said this argument was startling, which I just thought was kind of cool. See, sometimes they disagree with the department. Or they, yeah. The next one is NRA Brianna M. Now, I kept this one in because I started working on this PowerPoint, a couple months ago. However, it's important for you to know what Brianna M. says, but the footnote to that is this is currently pending before the California Supreme Court. So, it has to do with Department 414 and 2 dads. And in my own personal opinion, not the reflection of the law office of Marlene Firth or Ladle, Martinez was trying to do the right thing, and the Court of Appeal tried to help her do the right thing in deciding who was the dad. It was a situation where we had 2 men who qualified under the statute as presumed fathers, and she had to find one to be the presumed father and kick out the other one. What Brianna M. seemed to say was that a voluntary declaration of paternity does not confer presumed father status. Basically was the holding. For those of you who went to Martin Lee's wonderful voluntary declaration of paternity training, all that went out the window. But we have hope, Martin. The Supreme Court may help us out. I have not heard, and I don't know specifically about 414, I have not heard that our courts were following Brianna M. when we had fathers who were coming in saying, I'm on the birth certificate because I signed a voluntary declaration of paternity. At least in the courtrooms I've been in, they were still finding them to be presumed. But know that this is out there. Know that this is an issue that is on review for the California Supreme Court. There was another one that followed Brianna M., which was Giovanni B., which basically came out of the same courtroom, the same appellate division, and held the same thing. And I haven't looked it up, but I'm guessing it may have been republished or joined with the petition for review in Brianna M. Okay, jurisdiction. So starting with jurisdiction, we had Henry Nelson B., which is a UCC JEA case, everyone's favorite topic. The child, Nelson, came from Honduras, likes to see the world, so he came here by himself at 13 into the United States. He went to D.C., then he ran to Texas, and then he was picked up and placed with his aunt in Maryland. He lived with the aunt for at least 6 months. And that becomes important if you're familiar with the home state requirements of the UC State JEA. But then Wanderlust returns, and he comes to California, finds a girlfriend, moves in with her family. Gets in a fight with somebody in the home of his girlfriend, and the agency's called, and this kid's picked up. So the issue, of course, is who has jurisdiction on this kid who has kind of been seeing the world on his own. And the trial court basically said there's no jurisdiction because Maryland, where he was living with the aunt for a period of time that exceeded 6 months, is the child's home state, and the child appealed. The Court of Appeal basically affirmed the trial court's decision, saying that he lived in Maryland with a person acting as parent for at least 6 months prior to these proceedings. And I put this quote specifically in the slide because I liked it. UCC JEA bases jurisdiction on the residence and conduct of the persons having custody of the minor, not on the minor's unauthorized travels. So you have to look at where those 6 month blocks and where this child was living, regardless of his apparently quite savvy ability to see the world at 13. Enrique Gloria A., another UCC JEA case. The issue again was whether or not California had home state. The record was really unclear as to when mom and the daughter entered the state, but the mother was deported 1 month before the proceedings were initiated. And the Court of Appeal basically said you can't prove 6 months because their time living together and the time clock to run on home state ended when mother was deported. So it's an interesting fact because we do have a lot of cases involving deportation to kind of look at Enrique Gloria A. and see the Court of Appeal's reasoning on that basically when you lose the parent to, ICE or some other agency, they stop living together for purposes of UCC JEA. Okay, then we go to 300 subdivision A. I'm not sure I changed it in your hand. Let me check. The first case we have is Gonzalez versus Santa Clara County. if you could see my slide, you would see it's actually a 2014 case. On your handout, I put 2013, but I don't want you to get confused. The original opinion came out in 2013. There was a rehearing request filed and granted. So the Court of Appeal did a rehearing on it and then issued a revised decision that was subsequently published. So that happened in 2014. So you may have heard about this case. This is also affectionately known as the wooden spoon case, okay? But you don't get confused because it is now a 2014 case because of that rehearing and the decision. The decision did not change significantly based on the rehearing. I kind of compared it and quite honestly got bored because it was a little too tedious. So nothing significant changed out of the revised decision. This one thing, other important thing to know about Gonzalez is it doesn't necessarily involve Section 300 and dependency proceedings. It has to do with a parent's appeal from a CACI hit. But the reason I strongly suggest that you read this case is the Court of Appeal does an excellent job in going through law, legislative history, child abuse reporting, criminal statutes, everything relating to this issue of inappropriate discipline and what constitutes discipline, what constitutes physical abuse. And so if you have an A case, put this on your must-read list. Basically, this kid is a 12-year-old girl who was very interested in gangs. She liked to hang out with the wrong crowd. She liked to draw gang signs all over. She liked to cut school, started failing her classes. The parents were basically trying to do everything that they could to control her. They put her on a behavior contract. They found out that she had broken this behavior contract. The dad was at work. The mom calls dad. Dad says, I can't leave right now. Go ahead and give her a spanking. Because that happens. Mom takes a wooden spoon, smack, smack. Child goes to school the next day and tells his friend, I can't sit down because my mother gave me the beating. And it was reported. Of course, the police and the department were called. There was no counseling recommended. There was no petition filed by the DPSS of Santa Clara County. The abuse investigation by their agency, though, was substantiated. And so that's when the parents filed their notice of CACI appeals. And for those of you who aren't familiar with that process, when you have a finding, you can appeal it to the CACI Appeals Board. When the CACI Appeals Board comes down with their decision and you want to appeal that, that appeal goes to the Superior Court. And so the Superior Court basically upheld the finding of the CACI Appeals Board. Then, of course, your next remedy is to go to the Court of Appeal, and the Court of Appeal reversed everything. The Superior Court holding and the CACI Board. They use the child abuse definitions from the Penal Code about willfully inflicting upon any child cruel or inhuman corporal punishment resulting in a traumatic condition. And that's the language that they kind of cite over and over again. Their steps for determining what parental discipline is a genuine disciplinary motive, reasonable occasion for discipline, and disciplinary measure, reasonable in kind and degree. This kid had bruises. Not a significant number of bruises, but she did have bruises. And the court, I couldn't, honestly, if we had more time, I would go through this entire case for you because that's how important I think it is and how helpful it will be to you. They talk about that bruises don't necessarily, shift it over into abuse. They say on the next slide, we cannot say that the use of a wooden spoon necessarily exceeds the bounds of reasonable parental discipline. Yay. And then I did put on the next slide that their discussion about bruising and sort of their three-step analysis to why bruising in and of itself doesn't lead to this traumatic condition. Again, it's a CACI case, but there's so much good information in this opinion that you probably could use to hopefully persuade the bench or the Court of Appeal on where the line is between what is physical abuse and what is discipline, and appropriate or inappropriate in those lines as well. So I hope you start. We had a few cases under Subdivision B relating to mental health and domestic violence. The first one is NRA AG. This originally came out as A&G. So if you hear A&G, it's the same as AG. They switched it to the initials. Mom was amazing. Mom claimed she was the president, and then she was 5150. From there, she danced around. She claimed she was Jesus, claimed she received messages directly from God. Father had initiated divorce proceedings against the mother and took precautions not to leave the children alone with the mother. He hired like a full-time nanny to take care of the kids when he was at work. They slept behind, he and the children slept behind locked doors. This dad kind of did everything he could. Mother then was able to talk to Michael Jackson, Marilyn Monroe, the Kennedys, and Abraham Lincoln. President Obama told her to take her medications, but she only had insomnia, so she didn't. And Mother was allowed to represent herself in the trial. We all dodged the bullet on this one, okay? The court sustained the mental health allegation, placed the children with father, and then JT'd with a custody order, and Mother filed a notice of appeal. The Court of Appeal actually reversed the jurisdictional and the dispositional findings. They felt that the department didn't meet its burden of showing actual harm or risk of harm by Mother's behavior because of all the factors and all the precautions that Dad played into the family life. They never left the children alone. They left locked doors. He employed a nanny. And what the Court of Appeal indicated was that the court should have dismissed the petition and then stayed its order to give father the opportunity to go get a custody order providing for monitored visitation. So sometimes we see that scenario before petitions are filed when there's a family in crisis and the department will say, okay, go to family law court, and then they file because they don't think the parent did it fast enough. But it was an interesting comment from the Court of Appeal, and in my opinion, recommendation on how some of these cases should be handled. Instead of sustaining allegations against mom, that the court just should have dismissed and then stayed its order to allow a non-offending parent to go get a custody order. Yes, Amy.
As a practical matter, we were actually on this case. We were still on it. Okay. But as a practical matter, we all know that it takes more than a couple of weeks to get into family court and get a court order. If we have a case where that order stayed, then what happens? Can the court make visitation orders for that parent? Because essentially the court's dismissing the petition and staying it. That stay could last upwards of 5 or 6 months. So in the interim, can the court make any orders, in your opinion,
in my opinion,
advising
no.
the parents as to what they should do in the interim?
In my opinion, no. Because if the court dismisses the petition, the court no longer has jurisdiction. And so it doesn't have, even though we're staying that order, there's nothing, the children aren't dependents, there's no petition pending.
And there's no protective orders in place, so
Right.
technically that mother could have taken that kid and...
She could have, in this particular case though, I think the father was so protective that I don't know that that would have necessarily been an issue, but I also think it comes from, the Court of Appeal doesn't quite understand what happens here and how long cases take and what happens, and Danielle, Steve, and Rebecca, you can tell me if I'm wrong, but they don't always quite get the practicality of what do you tell your client and what happens the 2-3 months while they're trying to go get a custody order. But it was interesting to me that they even kind of put it out there on something that I hadn't really thought of.
They've had a couple of unpublished cases since that are cited to this case, but again, as Ellen said, they haven't explained how you should go about doing it because they don't understand, yeah. But they are sort of following this trend to do that.
Okay, let's leave our wonderful mom under A to G and go to, let's have some domestic violence. The Court of Appeal still loves domestic violence, but they certainly don't love domestic violence perpetrators. And in Inree TV, the court sustained the allegation of domestic violence. The father punched mother and stepped on her neck, but the child was at school. So how does that even show that they were risk at harm? And the Court of Appeal basically held, even though he wasn't present, the domestic violence between the parents was ongoing, likely to continue, and therefore it placed him at risk of physical harm. The father, noted, I think probably if you represented father, all the things you would, that the child was happy and healthy living with him. There was one incident while the child was at school. Unfortunately, when the Court of Appeal looks at the record, father had multiple convictions for spousal battery. The child had witnessed